Though
Oh,
actually, all my computers have a different time on them.
oh. Well, I don't know what time. I have 10 on my phone. So let's do this. So go live.
So I have 9:58 on my laptop, which I'm using, but on my desktop, which for right now is logged into the Western computer, that one's always wrong. That's at 10:08.
Okay.
But if
Well,
I log out of Weston and go by this PC here, it's 9:59.
oh, okay.
We
Well,
can't get the Western one to be right.
so let's go live and okay, but good morning. Today we are going early. Today is a very special day for Barton, so we are doing this early so he can spend the day with his beautiful wife and celebrate her birthday. Thank you so much for taking time to be with us. And as an introduction, always Barton Estro, it's our preferred real estate attorney, and he's a partner for my accent some days are worse than others. Stroke Cohen Zipper Group and Safety Title and Closing. And also, Barton is the Florida Supreme Court certified civil and county court mediator. Thank you so much again to be with us. And we are talking today about buyers and sellers read the contract. And I would like to for you to help us realtors when we fill some of the blanks and also put some additional terms, how that can take implications or commit for some let's see conditions on the contract that the buyers and sellers have to be aware, even also what is on the contract that they need to know when they sign for sale um, a contract for sale residential real estate. Today.
Okay, thank you, Jackie. Thank you for having me here today. I appreciate us starting early today. Um, I could talk for probably 5 hours on that topic, um, but we don't have 5 hours. My wife would kill me.
Yes.
Uh, um, so there are a couple of different issues. Let's break it down.
Mhm.
So fill in the blank. So realtors are very fortunate in this state that they have a fill in the blanks contract. There are other states that do not have a form fill in the blanks contract. And all the realtor could do is show the property and take a binder, they call it, a deposit, and wait for an attorney to write a contract.
Okay.
Um, so we're very lucky here because the Florida Supreme Court, sometime back in the 50s, said that realtors who fill in the blanks on the most up to date contract by a realtor authority, I don't remember what the language they used was, but like a board of realtors, are not practicing law without a license by writing that contract because it's fill in the blanks. Because if you use the most up to date contract, it's basically a checklist to fill in the blanks, mostly dates and amounts,
Yeah.
as to what um, the most current standards and practices are in real estate in your community.
Mhm.
We've gone more, as we discussed last week, to a standardized contract across the state of Florida with the FAR Bar as is contract. Um, it does have some local options in it. Um, so fill in the blanks, that's pretty easy, although sometimes the realtor doesn't notice the words that might come before, the words that may come after that modify what that is. For example, when you put in the date that this contract must be accepted by, a
Mhm.
lot of realtors don't know that right after that says, if not accepted by January 31st, 2024, the offer shall be automatically withdrawn. So if you accept it on February 1st, you cannot accept a withdrawn offer. It's like trying to shake hands with someone who's already put their hand in their pocket. So once an offer is withdrawn, either by telling you I withdraw my offer before you accept, or if the date and time passes to accept the contract, it's automatically withdrawn. You can't accept it. So those are the sort of things that I usually like to teach when I do live classes, webinars for realtors. If we have any brokers on the line, I would love them to invite me into their offices or by webinar to teach these things to their realtors. The second part of your topic was what happens when you have to write in a clause. In the additional clauses. I think that's paragraph 23. That creates a problem because if you write more than a sentence or something, number one, you could be practicing law without a license because now you're writing a contract, or you could screw it up. How often have I seen over the years not subject to appraisal? I don't know what that means. Okay. Because there are appraisal contingencies in the older contracts. The new one, it terminates with the financing provision. But that means absolutely nothing. Yet I see in the contract and people try to rely on it.
And also it's on MLS. When you see the listing, they said this, your offer is not subject to appraisal.
Well,
and that coming
you get financing.
Yeah, and also the person have to have the buyer have to have the money to, if the property is overpriced or the appraisal doesn't come at the agreed purchase price, the buyer have to have the money to cover that amount. But yeah, that's
so the realtor associations and the Florida Bar have tried to remedy some of those things with a whole bunch of addenda. Like there's the appraisal addendum, which tries to remedy some of those things. But what we do is most of the realtors we work with, before they'll write a clause like that, they'll call us and say, can you prepare this clause for me? And then we do, and then they use it over and over again, such as especially the clause that seller will close out all permits, violations, and even that gets revised over time because, we say they're gonna close out all open permits. Well, they also have to close out expired permits too. So we've added that to our language. Different things come up over the years because one city makes you close out expired permits. So we put it in there. What does the buyer or seller know? To read the contract and how do they get their answers? I think that's a big issue. First of all, we're dealing with a contract that goes on for pages and pages in small print of a lot of legal mumbo jumbo. And for many people, this will be the biggest contract they ever sign in their life. Not only are they making an investment in real property, but they're making an investment in their life because this is where their family is going to live.
Yeah.
And so, do they read the contract? My guess is they don't. Because when one of my biggest job in the firm is to see people after a deal goes south. When there's a problem with the deal, it comes over to me. And, people have no idea. Did you read it? No. Did you understand this? Well, this is what my realtor told me. Mm-hmm. So, a person should read a contract. If a person has questions about what a contract means, they could ask their realtor, but the realtor is not a lawyer. The contract is a legal document. And while a realtor could answer certain standard questions, a lawyer should be doing it. So our firm, and I don't want this to sound like an infomercial, Because there are other firms that do this like us, not that many, but what our firm does is we consider ourselves partners with the realtor. So if we're in Miami-Dade or Broward County and the buyer is selecting the title agent, we ask our realtors to refer them to Safekey Title, which is our wholly owned title company. But just because they're going to the title company, it doesn't mean they don't have open access at all times to the realtor, to the attorney, to any one of our three partners to answer a question. So, let's say Michelle is the processor. They'll call Michelle with a question. Michelle will say to the realtor, that's best answered by the attorney. Let me connect you. And I'll say to the realtor, listen, do you want to get your client on the line? And we'll have a discussion about it. Or let's set up a time for the three of us to talk. Because to us, that's included in our service, both to the buyer and to the realtor. Because we're a partnership together to get this deal closed, to have the buyer happy so that the buyer has no trouble after closing. The realtor gets repeat and referral business from that buyer. And we get repeat and referral business from that realtor. And sometimes from the buyer also. I mean, if they bought an investment property, I want to handle their landlord tenant matters and any other matters that come up in real estate, because that's what our firm does. So that's how it works with the buyer. For the seller in Miami-Dade, Broward, a lot of times the realtor will tell the seller, well, the title company will take care of everything, preparing your documents. And the title company is going to charge $750 plus wire fees and all sorts of junk fees. It's going to go up to close to $1,000 that they're going to charge just to prepare the documents, do the closing. Even though some of those fees aren't even allowed by the contract. But who's watching out for that seller? Nobody. So also, many of the realtors we work with refer in Miami-Dade and Broward, refer their sellers to us to represent them. We prepare the contract. We prepare the seller's docs. We advise the seller. Most important, we check the closing statement, which probably 80% of the time we'll find a mistake on that closing statement that would hurt the seller. We get it corrected to benefit, and we charge a flat fee of $950. But the seller now has legal representation for a legal document, a contract, and the closing that contract foresees. Disputes arise during it. It's better to have the attorney in on the beginning. It keeps the title company honest. The same goes if you go to Palm Beach County or Orange County, where the seller selects the closing agent, which actually more counties in the state have that system than Miami-Dade and Broward. So in that case, the seller is selecting the closing agent. The seller is doing all the work. It's their closing agent who's beholden to the seller or the seller's agent who has hired them. And all the buyer is getting a title policy and a deed and a closing statement that nobody knows. Nobody has checked for this buyer to see if it's right, to see if the title is correct, to see if the liens, if they read it correctly or they didn't hide anything. So we recommend in those counties that the buyer hire an attorney to represent them. Well, will every title company do that for him? No, because Safekey Title is a licensed title company licensed by the Florida Department of Financial Services, DFS, Department of Insurance. The law firm is licensed by the Supreme Court of the state of Florida. We're lawyers. But most title companies out there are run by licensed title agents who have no ability to provide legal have no legal expertise and have no right to give advice to people. even in many cases of attorney-owned title companies, the attorney may not even be a real estate attorney. He's just hired a paralegal to run that section of the business. And he doesn't know anything or just chooses not to get involved with that and handles other stuff. I've seen that too. So you need an attorney-owned title company or a law firm that knows real estate and is fully involved in that process. And I mean, in our firm, an attorney reviews the contract and will let you know right away, hey, you passed the date for acceptance. You better correct this, or because you have no contract now. We'll look at the last deed and say, hey, you don't have all the sellers signed. What's the issue here? Where's that other seller? Why is the buyer's name different than on the license, copy of the license you sent us? We start that process from the minute you send us the contract. We look at all surveys. We review all title commitments. Of course, the attorney signs off on all the docs, including the closing statement. And in most cases, an attorney does the closing and is able to answer your legal questions about the mortgage and everything else.
Yeah. I have a situation now that caught me yesterday for a closing I have at the beginning of last year. And one of the sellers, I was representing the seller, the buyer chose his title company, and one of the sellers was deceased, and they asked me for the original of the certificate. It was provided, and everything wasn't good. Yesterday I received a phone call that said my buyers cannot have a homestead exemption because the county didn't change the buyer's name as an owner because it's a mistake on the name of the person that is deceased. And I go like, and who fault is that? Like, I provide all the documents, and it was your title company who do it. No, you don't understand. You have to help me. I go like, okay. Perfect. And so she said, like, did you know the person who passed? No, that person actually passed a few years ago, and the kids, the daughters were in charge, and one of the daughter was on the deed with the father, and it's like, but you have to help me. And I say, what I supposed to do? And she said, like, you have to find an affidavit. And it's like, I was like, okay, can I talk to the title company to know? Because how, after a year, they didn't file for the homestead and they didn't know, and how the attorney or the title company didn't notice that. And almost a year after, I have to run with an affidavit that somebody have to know this person and know it's a different on the name and the initial. So in one, they use one name and one initial, and on the death certificate, they use the other name and one initial. And it's like okay, and it's like it is that also I feel bad because after I close and they sign the deed and everything, they receive all the document, I just step up because it was not my buyer, was the seller. So, and now I feel like, do I have to check also that they change on the county the names after the closing?
No, I see this all the time, by the way, that the county refuses to, while the deed is recorded, they refuse to change the title for that parcel.
All right.
Because something is wrong with the deed. Either it's the legal description or all of the parties don't match up. Because for title purposes, whatever comes into someone must go out to someone.
Yeah.
Unless there's another document recorded that explains the difference, such as a probate, a power of attorney, or something like that, a judgment. So, yeah, the counties are becoming more and more critical of the quality of the deed that goes in. I'm forever filing quiet title lawsuits to correct those things, because in many cases, the person's been dead for 20 years. And a title company,
5 years. That
and a title company that does not have the involvement of attorneys is not qualified to handle and review legal documents to make sure it's exactly correct.
So in cases where we use, yeah, you said that we have some additional terms that are sometimes written by an attorney, and we use again and again. For the open permits, that it's what I see the most in Miami-Dade, that they have a lot of constructions done. There are no legal or open permits for previous owners. I don't know, with cash deals, and they go and go and go. How we can protect, or what would be the best for understanding the seller in this case to do in these cases? What
Well,
how
you have to put in the language that the seller is going to close all open and expired permits, cure all violations as disclosed by a lien search. But you don't even know, there may be violations that nobody knows about. Because if you didn't file for a permit and you did the work, the county might not know about it till 2 or 3 owners later, when someone comes in to issue a permit, an inspector comes and looks and says, when did those windows get put in the back of the house? I have no list here of a permit done on this. I have a client who just last week was woken up at 7 o'clock in the morning, knock on the door from the Coral Springs code inspector, with a stop work order. Well, he's just a tenant. But apparently there were windows put in, AC put in, walls moved before he moved in, interior walls removed to open up the house, all without a permit. I don't know if those were load-bearing walls or anything.
Yeah.
So, the seller needs to tell the truth. Okay, that's the first thing. On any disclosure, if you had a leak, then you had a leak.
Mm-hmm.
If you fixed it, you say, I fixed it. Here's what I did. Here's the receipt for what I did. Don't say, no, there are no leaks when it asks you, were there any leaks, ever any leaks? So the listing agent needs to let their seller know that they need to disclose the truth. Okay? Because what happens is they're either going to get sued, or if it does come out on a lien search, now they know. And so the realtor is then in a pretty bad position, because now the realtor has to inform people. Even as a transaction broker, they have a duty of honesty.
Yeah.
And so if the seller says, I don't want you to tell anybody, then they have to say, then I can't be your realtor.
Mm-hmm.
So you need to get the truth in there. Buyer could do all the inspections they want, but a good inspector might be able to see code violations that have not been cited. A good inspector, some will check the permit records, say, those are fairly new windows. Let me check and see if a permit was pulled on those.
Yeah.
These are discussions you need to have with the inspector you're dealing with. Do you do this?
Definitely is.
Mm-hmm.
Okay. So anything that inside the contract that it's already written, that we don't put anything, have to be aware of the basic, the buyers and seller understand what it's the implications to sign it, like without no scare or whatever. Just
the financing provision.
Okay.
That's the most important part for a buyer and the seller to know, because there are deadlines, strict deadlines. That is the most loss of deposit cases I see. Mm-hmm. Is the 30 days financing provision or whatever has been agreed to passes, and no one sends a notice that we got financing, we didn't get financing. We didn't get financing, but we elect to continue. And from the seller's point of view, the seller could say, listen, this is a rising market. I could sell this for more money now. The seller has 3 days to cancel. if the buyer doesn't send any of those notices that I got a mortgage. Instead, the seller has to wait 30 more days, get a default, fight about the deposit when they could have had the property sold already. So there are seller's rights in that also. So, a buyer should know, listen, I have X days to get an approval from a lender, which includes the appraisal.
Mm-hmm.
Okay. And if I don't have it by day 30, there is a notice, or if I get it by day 30, there is a notice that I must send to get further protection under the contract or get my deposit back. That date is written in stone. Can the parties extend it by agreement? Yes. But what I see is they use the standard form extension addendum that says the closing date is extended 30 days, but they never check the box that says the financing contingency period is extended.
Yeah.
When that's what you're waiting for. And so you sign that to extend the closing, which is just to delay the death, just to delay the loss of deposit.
Yeah.
Because they didn't get financing. They're probably not going to get financing after that period of time. Okay? So that's important. The number of days for inspection is important, that the buyer needs to understand that. Okay? And those need to be written in stone. They need to be written on the realtor's folder and say, this is what I must do, because they may not be able to hold you legally responsible, the realtor, for those dates passing, because the realtor is not your lawyer. And that's what the realtor's E&O carrier is going to reply. It was the buyer's obligation to send notice within 30 days. Nowhere did the realtor assume that obligation. The realtor is not a lawyer to advise them. Okay, that's what the buyer is going to say. And the same thing if the lender says, we'll have it for you in 3 days. Don't worry about the 30 days. And then they never get it. It's not their obligation to give that notice. Okay. Yeah. So if a realtor wants to keep their clients, it's so much easier to get repeat referral business than have to look for a new client every other week. As you know, Jackie, you get a lot of repeat referral business, as we do. You need to make sure that those letters go out, those notices, okay? And they can't be by text message anymore. They must be by email or written. Mm-hmm.
Yeah, it gets frustrated sometimes. I'm few years in this business in 2 different areas, in 2 different part of the state, and I see how sometimes I can be as honest I am. I have good title companies in Orange County and Osceola County that I work with, but it was a change in my brain for me when I moved to South Florida. And it's the fact that it's so necessary to work with an attorney, because it is just a different animal. It's a different way to do, and it's more details that we have to take in consideration. And also sometimes dealing with some extensions, the loan approval period, and then the listing agent trying to include in that addendum, scratch the addendum and said, okay, well, we are standing, but I want to put and scratch addendum. It really hurts my feelings every time somebody scratch or add something without asking me. And then I have to or put an addendum back or talk to the buyer and say, like, this is going on. And
that's why you can't wait for the 11th hour of the 30th day to start the process of seeking an extension. So when I send out an extension request for inspection or for financing or anything at all, what I put in my email is, if this is not accepted by 11:59 tonight, which when the financing contingency ends, then this will be considered a cancellation at that time and a request for refund of the deposits. You got to put that in there and let them know, because otherwise they're going to delay you past the time for that deposit contingency to expire.
No,
and you can't do it at the 11th hour.
Yeah, no, I send everything at the same time. And I have and I have my buyers, sometimes they go like, Jackie, go, I'm sorry, I will not go over your money. It's somehow it's my responsibility. And if they are playing hard, you have to know what they are doing, and it's your money. Unless, you want to just send me a letter and say you are not responsible for anything. But this is what we are having right now.
It's the same thing as what service you provide to get your business. So if I go into a furniture store and say, buy a couch, and I give the guy $2,000 for the couch, he doesn't say to me, okay, it's yours, come pick it up, Then he says, oh, we're going to deliver it to your house. We're going to do this for you. We're going to do this for you. It's the service that you provide. I provide the same title insurance policy that's used in the United States and the Caribbean basin. Okay. Yes, there are different endorsements available in different states. Florida is highly regulated. We have a limited number of endorsements. California, there are hundreds of endorsements available, most of which are ridiculous. But so it's the service that I give with that title policy to make sure that it's correct, to make sure that someone's not going to come knock on that buyer's door a year later, 2 years later, and say, oh, I have a claim on this house, or your deed is defective, or a summons, a process server, serving you with a summons to quiet title and get you out. So that's what counts, what service you give. And by the way, it's the same in that respect in Orlando, either Osceola or Orange County, and here. While the people may be nicer to deal with, they're not as crazed and fast-paced as we are down here. The fact is, you're still not going to let your family practitioner do brain surgery on you, even in Orlando. So, the same things can happen, and the people should have the protection of an attorney, even if it's just a consultation.
Yeah, that's absolutely right. But thank you so much. I will not take more of your time. You give me a lot. And thank you. I see you next week. We will have a good one next week. And then you are going on vacation. And I hope you have an amazing day with your wife. Please say to her happy birthday in my name. And see you soon.
Okay, bye-bye. Have a great week, everybody.
Yes.